In the past 20 years, I've mediated or arbitrated about 400 medical malpractice cases. I've learned in mediating or arbitrating these cases a number of important lessons. First, they are extremely difficult cases for plaintiffs to win at trial. The burden of proof is a very high hurdle in this regard. Plaintiffs have to prove in most states a couple of important things. First, they have to prove that a doctor or a hospital or a nurse has violated an applicable standard of care. This requires expert medical testimony. Historically, defendants, for financial and political reasons, have a much easier time of finding convincing experts than do plaintiffs. Second, even if plaintiffs can find one or more physicians to testify that the defendant or defendants have violated the standard of care, they also have to prove that these violations caused the injury or death. Defendants win many trials losing the standard of care skirmish, but winning on causation. What's unusual about medical malpractice cases are a couple of things. First, for plaintiffs and their family members, they are very emotional and painful cases. Second, they're often extremely technical. They are the factual, the medical, the scientific issues are often difficult or even impossible for jurors to understand. This particular aspect always favors the defense, the party that does not have the burden of proof. Mediation is by far the most popular form of alternative dispute resolution of these and almost every other case. When medical malpractice cases are arbitrated, is often because a physician defendant who has the right to grant or withhold consent in most physician insurance policies has refused to consent to settle. Doctors refuse to consent to settle often because of state and federal reporting requirements regarding settlements. I would say most of the medical malpractice private trials or arbitrations I've done have occurred precisely for that reason.